So, this is the reply to the state's objection to motion in limine number 6 regarding Nowlin touch and contact DNA. Comes now, Brian C. Kohberger, by and through his attorneys of record, hereby respectfully replies to the state's objection to Mr. Kohberger's motion to exclude specific opinions of Rylene Nowlin and the terms touch DNA and contact DNA. The state's objection is that the use of the term touch DNA will not mislead the jury. That Nowlin's testimony on the, quote, how the DNA was placed on Q11 is, quote, proper expert testimony. And that despite Nowlin's opinion being the state's theory, that it is proper rebuttal to the testimony of the defense expert, Dr. Ruth Ballard. Mr. Kohberger will address each objection in order. Objection A. The use of the term touch DNA will mislead and confuse the jury. In Mr. Kohberger's motion in limine number 6 at 3 through 8, he sets forth in detail the history of the use of the terms, quote, touch and contact DNA, and the growing use of those words. So much that a recent report from NIST offered the recommendation that analysts should not offer opinions as to the how and when that a particular DNA sample came to be on an object. The state's opposition argues that the only purpose for the use of the word touch in the context of DNA is to distinguish between samples that collected from a known or visible stain, such as blood, saliva, and semen, and DNA that may be deposited on an item by handling or wearing. So the state's opposition argues that the only purpose of the use of the word touch in the context of DNA is to distinguish between samples that collected from known or visible stains, such as blood, saliva, and semen, and DNA that, quote, may be deposited on an item by handling or wearing. What this argument fails to consider, and Mr. Kohberger forcefully explains, the use of the word, quote, touch in the context of DNA implies a fact that is not known. The fact being that the DNA was in fact deposited via touching the object, which is not known. The implication of the word is the issue, not the description, the type of sample, or the means that the DNA transfer through the environment. The implication of the word is the issue, not the description of the type of sample or the means that DNA can transfer through the environment. A close reading of Nowlin's now 3 disclosures, footnote 1 here says she has a new different disclosure from Nowlin that was filed recently, March 14th, 2025. This disclosure was not touched on in motion in limine number 6 because Mr. Kohberger had yet to see it. So isn't that interesting? She got to file a new disclosure on March 14th, 2025. Okay, so that was footnote 1. A close reading of Nowlin's now 3 disclosures shows the inherent problem with the use of the word touch and lack of any need to use the term. In her first disclosure, Nowlin describes the ways in which DNA can move in the environment using language such as direct, indirect transfer without use of the word touch, except to describe the action of a person actually touching an item and transferring DNA. In the March 3rd, 2025 disclosure, Nowlin, for the first time in 2025, March 3rd, for the first time uses the term, quote, touch DNA as a descriptor and not a verb. If the court simply removed the word touch from the disclosure, the description of the concepts laid out would not suffer and would be as clear as the earlier similar description in S7. Nowlin seems to switch between using the word touch in reference to describing a type of DNA, indicating that it is not necessary to offer a cogent description of the process or transfer laid out in her disclosures. I got to know what that word means. Sorry, you guys. If you haven't been here long and you haven't listened to me before, if I see a word that I'm not sure of, I Google it because I want to know how to say it and what it means. Da, 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 da. Cogent, adjective of an argument or case, clear, logical, and convincing. Okay, cool. Yeah, okay, cool. So clear, logical, and convincing. Cool. Cogent means clear, logical, and convincing, right? Cool. Cogent. Okay. The state cites to a single case for the proposition that experts in other cases have used the phrase touch DNA. This case is from 2016 and discussing the availability of technology to test touch DNA in the time frame from 2007 to 2012. In further support, the state offers a single article which references sampling methods for touch DNA. It ignores the articles cited by Mr. Kohberger, which are reviews of the literature. These reviews cover in total over 300 scientific articles as compared to the single article presented in the state's opposition. The state has presented no articles advocating for the use of touch DNA. Finally, the state offers Nowlin's statement that the term is typically used. So they're saying that she's saying, yeah, it's typically used. Footnote 2. Nowlin also points to the use of touch DNA in Dr. Ballard's disclosure. Mr. Kohberger understands that if the court grants his motion, Dr. Ballard will not be able to use that term. There's another footnote there. We'll get to it when we get to it. No peeking. All right. The state does not present any documents, peer-reviewed journal articles, or other materials that advocate for the use of the term touch or contact in reference to DNA samples taken from an item where the lab did not see an obvious body fluid stain and did nothing to determine the presence of any possible biological source. Footnote 3. Footnote 3 says the state could have conducted blood, saliva, or semen testing to eliminate or establish the presence of one of these fluid types, but chose not to do so. Interesting. Nowlin's affidavit offers no support to the necessity of using the term touch DNA, other than to state that it is a term that is widely used. Nowhere does she point to any references that support that position, that this is the only means available to describe the type of sample that is being tested. As is clear from her previous disclosures, she very clearly and concisely describes transfer as a concept without using the term, meaning without using the term touch. The first time she uses the word touch is this year, March of 2025. None of this is convincing and does nothing to rebut the peer-reviewed opinions of the author cited by Mr. Kohberger, that the use of the terms can be misleading and suggests a mode of action which is unknown. Footnote 4. Footnote 4. Mr. Kohberger in no way suggests a substitute for the word touch or contact. Nowlin's disclosure clearly shows that a description of the concept of transfer does not require the use of the touch or contact for the explanation, and testimony to be clear and cogent. Ooh, there's that word again. See, and my brain fog's real. What did it mean again? Cogent. Damn it. I kept the tab open. Clear, logical, and convincing. Okay, cool. So what they're saying here is that she, in other disclosures, has described the DNA on the sheath as transfer and hasn't used the word touch or contact up until this year, 2025. So she did it before, right? She could give this explanation again, and it could be cogent. It could be clear, logical, and convincing without needing to use the word touch or contact, right? Let me pause here for a minute. Sound right, friends? Come back to chat. Hello, hello. Welcome in, everybody. If you joined and I was in another window reading, so sorry. Janet UK, hello. Chief, hi. Thomas, Oaxaca, hello. ADH Stacy. Who else did I miss? My goodness. Hopefully my mods welcomed you right on in. For fuck's sake, Fitziana, there you are, darling. Hi, honey. How are you? Twiz, where are you at? Where's Twiz? Well, Twiz is in here somewhere, but my chat's flying. Elizabeth Munster, hi. I'm just trying to get through comments. Jesse, hi. There you are. Twiz, what up? I think now where's Willie? Mary Holt, hello, welcome on in. Let me get through my chat here. Holy crapola. Hi, guys. Appreciate every single one of you. Dory, hi. Oh, my goodness. All right. If I missed you, I'm sorry. I'm sorry. All right. So I think I read that right. I think we got the word cogent correct, right? And I think what she's saying is that Miss Nowlin could have explained all of this, which she has previously done in other disclosures. She referenced when referencing this DNA sample off the sheath. Up until 2025, she's never called it touch or contact till recently. So, okay, Granny, hello. So, Yvonne Poole, you just got here. Well, welcome in, darling. All right, let me get back over here. So, if I didn't get that correct and didn't interpret that correct, as I've always told you, don't listen to anything I say, right? Read the documents yourself, come to your own conclusions. I'm just here to read and give my opinion. So, none of this is convincing, and she could have done all of this without using the word. Perfect. Where were we? Footnote 4, right? Damn it, Annie, get it together. Yeah, somewhere in here. Yeah, it was right there. Footnote 4. Okay, cool. The use of the descriptors touch and contact DNA are not necessary to the description of transfer laid out in Nowlin's disclosures and would only mislead and confuse the jury and require a significant consumption of time and cross-examination to prove a point that the state seems to concede, which is that the use of the word is not intended to imply the how of the DNA on Q11. Reason B. Objection B. The opinion of how the transfer DNA to Q11 is not proper expert testimony. To rebut the citations to the research on the topic of transfer and analysts' ability to assess transfer in a particular case, the state offered a brief conclusory affidavit from Nowlin. This affidavit does nothing to assure or assist this court in coming to a decision. As stated in motion in limine number 6, the state intends to offer Nowlin's opinion. I keep wanting to say Nowlin. I am confusing her first name. I'm literally mixing her first name with her second. Nowlin. That's what my brain wants to say. Don't ask me why. But when I read her name, I want to say Nowlin. No disrespect, for real. None. It's just for some reason my brain puts her first name with her last name and then puts it together. Let's try this again. This affidavit does nothing to assure or assist this court in coming to a decision. As stated in motion in Limine number 6, the state intends to offer Nowlin's opinion that the DQ11 is from direct contact, despite acknowledging that, quote, current DNA technology cannot conclusively answer the question of when DNA was deposited on an item or by what mechanism, end quote. Nowlin essentially places her subjective personal opinion in direct contradiction that the technology used cannot answer the question. This type of opinion and testimony is exactly the type of misleading testimony that the EWG group was concerned about. Let's see. As set forth in motion in Limine number 6, Mr. Kohberger objects to the specific testimony of Nowlin regarding her opinion that the DNA found on Q11 is, quote, more likely the result of direct transfer. A qualified expert, quote, may testify in the form of an opinion only if their specialized knowledge will assist the trier of fact to understand the evidence or determine a fact in issue. Because a verdict cannot rest on speculation or conjecture, expert opinion, which is speculative, conclusory, or unsubstantiated by facts in the record, is of no assistance to the jury in rendering its verdict, and therefore it's inadmissible as evidence under Rule 702. Let's see. And then it cites here Orion v. Beisner. The admissibility of expert opinion testimony depends on the expert's ability to explain pertinent scientific principles and to apply those principles to the formulation of his or her opinion. Thus, the key to admission of the opinion is the validity of the expert's reasoning and methodology. In resolving these issues, the trial court should not substitute its judgment for that of the relevant scientific community. The trial court should not substitute its judgment for that of the relevant scientific community. The court's function is to distinguish scientifically sound reasoning from that of the self-validating expert. Wow. Let's read this again. The trial court should not substitute its judgment for that of the relevant scientific community. The court's function is to distinguish scientifically sound reasoning from that of the self-validating expert who uses scientific terminology to present unsubstantiated personal beliefs. Damn. Bicka Barlow came for the throat here, huh? Almost positive it's Bicka Barlow, if I remember correctly, who did this. We'll see at the end. I'm almost positive this is Bicka Barlow. So she's citing Ryan v. Beisner here. The court's function is to distinguish scientifically sound reasoning from that of the self-validating expert who uses scientific terminology to present unsubstantiated personal beliefs. Damn. That's a burn, huh? Burn. Wish I had that sound effect. Burn. All right, let's see. 1. Nowlin is not an expert in transfer. The first question for the court is whether Nowlin has the proper expertise to proffer an opinion of how the DNA arrived on the sheath. First question for the court is whether or not Nowlin has the proper expertise to proffer an opinion of how the DNA arrived on the sheath. As set forth in Mr. Kohberger's motion in Limine number 6, the how and when opinions require a different type of expertise that exceeds that of the and expertise of a DNA lab analyst. Okay. The expertise for the how and the when is not going to come from just your standard training DNA lab analyst. And we'll get further into this if Audrey is here. Audrey's probably going to love it that they're citing sidebar, friends, sidebar. Audrey shared something with us the other night. I think it's in this document here. It just so happens to be something Audrey shared on a community tab, this conference that Nowlin attended, 2025. I think it just so happens to be the conference is around the time she's using the word touch too, if I remember correctly. We'll get into it. But yeah, just wanted to sidebar that. Audrey, I don't know if they saw your stuff, they saw your post, but girl, they're citing the same thing you did the other day, darling. All right, let's read this again. As set forth in Mr. Kohberger's motion in Limine number 6. The expertise for how and when opinions require a different type of expertise that exceeds that of the standard training and expertise of a DNA lab analyst. Nowhere in its reply does the state address the question of Nowlin's expertise in this area, nor does Nowlin in her affidavit. Not mentioned by Nowlin in her affidavit is the recommendation of EWG. Interesting. Not mentioned. This recommendation, so footnote 5, right here, not mentioned by Nowlin in her affidavit, is the recommendation of the EWG footnote 5. This recommendation was objected to by 2 of the 25 members of the EWG, quote, not because training on this subject is not important or necessary, but because they question how SPs will determine what experts are for TPPR and formal activity evaluation training, as well as what constitutes, quote, appropriate professional guidance in the United States. They are also concerned that currently available guidance might not employ the necessary safeguards that typically exist in a quality system of an accredited FSSP. Validation, competency, and proficiency testing, appropriate discovery reporting processes, and similar measures. Additionally, as stated in their objection to 7.1, these members believe Recommendation 7.2 is premature until Recommendation 7.3 is implemented. Then they give us that here, 7.2. So Recommendation 7.2. The evaluation of DNA results given, quote, how and when questions is distinct from the evaluation of DNA results given who questions. In order to develop policies and practices on how DNA analysts should respond appropriately to questions about how and when DNA was deposited in a particular case, forensic science service providers should consult professional guidance, documents, and experts who understand issues related to transfer and persistence. These policies and practices should require DNA analysts to be appropriately trained to respond to such questions. A close review of Nowlin's experience shows that she has no specialized training or experiences in the area of transfer. Her CV attached to Disclosure 1218-2024 S21 lists no substantive training in the area of transfer. It appears, here we go, Audrey, darling, this one's for you. Maybe you already read it. I'm sure you did. It appears that she may have attended some presentations at the American Academy of Forensic Science meeting in February 2025. Well, would you look at that? Oh, well, would you just look at that absolute coinky dink, right? What a coinky dink. February 2025, she goes and attends the American Academy of Forensic Science. She goes and sees some presentations. And then, well, look at that. By March of 2025, all of a sudden, for the first time ever in this case, she's saying the words touch and contact. Wow. The coincidences, they stack and stack and stack. Let's read that again. It appears that she may have attended some presentations at the American Academy of Forensic Science meeting in February 2025, but she provides no details regarding the presentation she attended, despite the fact that the materials were available online. And then they give you the link for the materials, Audrey, darling. There you are. That's like Christmas for you, I'm sure. Huh, honey? If you're in chat, I can't see my chat, but Audrey, if you're listening, this is probably like Christmas for you. All right. None of her presentations or publications involve transfer, and she has pointed to no research or experience she has in the area of transfer to substantiate her ability to offer an opinion on the how and when of the DNA in this case. While Nowlin may be qualified to testify about DNA testing, she is not competent or qualified to offer an opinion regarding the specific evidence in this case. Number 2, the opinion of Nowlin regarding direct transfer is speculative and not founded in sufficient facts. And then it cites here, Idaho courts have long held that speculative expert testimony is inadmissible. Quote, testimony is speculative when it theorizes about a matter as to which evidence is not sufficient for certain knowledge. An opinion that is speculative suggests only possibilities and may be properly excluded since the opinion would not assist the trier of fact. Expert testimony will assist the trier of fact when the reasoning or methodology underlying the opinion is scientifically sound. In determining whether expert testimony is admissible, the court, quote, must evaluate the expert's ability to explain pertinent scientific principles and to apply those principles to the formulation of his or her opinion, end quote. And then quoting Ryan Supra, while the court must distinguish scientifically sound reasoning from that of the self-validating expert who uses scientific terminology to present unsubstantiated personal beliefs, it may not substitute its judgment for that of the relevant scientific community. Here, Nowlin presents an opinion that the Idaho Supreme Court specifically warns against a personal belief presented as a possibility without any scientific basis to support that opinion. In response to Mr. Kohberger's motion in Limine number 6, the state filed a short affidavit from Nowlin reasserting, without any factual or scientific support, that, quote, there is not a consensus in the forensic community that DNA lab analysts should not opine about DNA transfer, persistence, and recovery. In support of this argument, Nowlin points to the dissent of the two of the EWG members to the recommendations from the EWG that analysts not present these opinions. However, this statement by Nowlin is incomplete and misleading. While Nowlin is correct in that 2 of the 25 members dissented, their dissent is not supportive of Nowlin's position because they, like all other EWG members, agree that this type of testimony can be misleading and otherwise problematic. Quote, 2 members do not support recommendation 7.1. While they acknowledge that analysts are often asked to respond to how and when questions in criminal cases and agree that testimony on this subject can be misleading or otherwise problematic, they believe that the broad prohibition in Recommendation 7.1 puts the proverbial cart before the horse by not first requiring an assessment of the type outlined in Recommendation 7.3. Moreover, they worry that supporting 7.1 would imply the need for analysts. I think this is a typo. Oh my God. Brain's gonna explode. Moreover, they worry that supporting 7.1 would imply the need for analysts to shift to a new paradigm that has not yet been sufficiently vetted within the specific context of the U.S. court system. So these EWG members are saying, right, 2 members who are saying they don't support the recommendation of 7.1, right? If you're asked, analysts are often asked to respond to the how and the when questions in criminal cases. And these 2 members agree that testimony on this subject can be misleading or otherwise problematic. They believe that the broad prohibition in Recommendation 7.1 puts the proverbial cart before the horse. So first, they require an assessment of the type outlined in 7.3. Go to 7.3 first, right? And moreover, they're worried that supporting 7.1 would imply the need for analysts to shift to a new paradigm that has not yet been sufficiently vetted within the specific context of the U.S. court system. Interesting. All right. They cite it here. This objection is not an endorsement of this type of testimony. Rather, it voices concerns that essentially there is no adequate training or system in place to support the scientific validity of the how and the when. Right, because there isn't. Who determines who the experts are of the how and the when? What's the training for it? Who peer reviews you? What standards do you have to abide by, right? How do these DNA analysts become touch transfer experts, the how and the when? How can they become experts on the how and the when? And who determines what training needs to be done for them to be an expert on those 2 things, right? It's not in place yet. Nowlin next points to the lack of consensus within the forensic DNA community on the use of this type of testimony. However, this is more argument than fact. Nowlin asserts that, quote, the other side of the debate believes that not offering an opinion based on knowledge of molecular biology DNA when it may aid the trier of fact is unethical, and that there were presentation on both sides of the argument at a recent meeting of the American Academy of Sciences. Interesting. Nowlin does not provide the identities of the communities she cites for support or any article or presentation that supports her statements. Nor does she explain how ethical norms are being violated or that there are ethical guidelines that support this contention. Nowlin has presented no specific arguments or research on the topic that supports her opinions as is demanded by Idaho law and so clearly stated in Ryan Supra. And then it's quoted here, the admissibility of expert opinion testimony depends on the expert's ability to explain pertinent scientific principles and to apply those principles to the formulation of his or her opinion. Thus, the key to admission of the opinion is the validity of the expert's reasoning and methodology. Even in a signed affidavit, Nowlin can produce no scientific principles that apply to the formulation of her opinion, and she has offered this court no reasoned basis for her opinion other than two bare facts. The court needs to consider carefully her full opinion. This is her full opinion. Quote, many complicated factors can influence the likelihood of transfer DNA and the persistence of the transfer DNA after deposition. Current DNA technology cannot conclusively answer the question of when DNA was deposited on an item or by what mechanism, meaning direct or indirect transfer. It is possible the DNA detected on M2022-483 item 11 resulted from secondary transfer. However, based on Nowlin's training and experience, it is her opinion, given the quantity of DNA detected on M2022-483 item 11, 0.168 nanograms, and given the DNA profile obtained as single source, it is more likely the result of a direct transfer. End quote. Stop here for a second. So even in her own affidavit, she does say it is possible the DNA detected on item 11 resulted from secondary transfer. But based on her training and experience, it's her opinion, given the quantity. Now, it's my understanding this quantity here is the concentrated amount, I believe they call it, not the actual amount of DNA that was recovered. I'm not sure. I could be wrong on that. It's my understanding that's like the concentration amount. I could be wrong. If I'm wrong, fine, I'm wrong. Cool. I'll eat my words happily. No problem. So, but she does say it is possible the DNA detected on the sheath, that's item 11, resulted from secondary transfer. It's her opinion that it came from, that it's more likely that it's the result of a direct transfer. That's her opinion. First, Nowlin explains that there are many complicated factors affecting the transfer of DNA. She states that the current technology cannot conclusively answer the question of how and when of transfer, and explains that the DNA on item Q11 could possibly be due to indirect transfer, but that her own personal training and experience led her to the conclusion that the DNA is more likely due to direct transfer. Nowlin essentially offers the court and ultimately the jury a confusing opinion that the science does not allow for conclusive determination of how and when of transfer, and that both scenarios, direct and indirect transfer, are possible, but she believes that the direct transfer is more likely. This opinion could not be more speculative. Quote, an opinion that is speculative suggests only possibilities and may be properly excluded, since the opinion would not assist the trier of fact. This opinion would not be helpful to a jury and would tend to confuse and mislead the jury. Nowlin only offers possibilities based on no substantive scientific principles, and which flies in the face of the science that Nowlin herself agrees with, that this type of opinion cannot be conclusively determined. Mr. Kohberger would be prejudiced by this speculative opinion, and substantial court time would be consumed in the cross-examination and impeachment of this witness. and this opinion, and therefore this opinion should be excluded. And yeah, it's Pick a Barlow. Well, holy guacamole. Now I can come back to chat. What do you guys think about that? Holy crap, oh friends. I'm sure there's a ton of you here.